We at Tiwari and Associates have been bringing you a series of web-based seminars. All of these have been brought under the able guidance and support from the Punjab and Haryana High Court Bar Association. Today, we are touching upon an issue which is very old in sense. As all of our panelists will tell you, racial discrimination is one of the main things that was discussed by the Constituent Assembly and is as relevant today as it was then. Just a quick segue before we begin. How we will navigate this is in a simple way that each panelist will go one after the other. If anyone amongst the attendees has a question or wishes to talk, we request you to write the same and send it to us, and we'll ask it to you on your behalf. How you can do that is by clicking on the tab marked questions and writing out your question with your name. At the end of the web seminar, we'll try and connect you, but if we can't, if for some technological reason we can't access your microphone, then we will read out the question that you sent it. I'd also request that if you want a particular panelist or a response from a particular panelist, you just mention that in the question and we'll put it as it is. Without further ado, I'd request our first panelist, Ms.Eliza Barr, Standing Counsel for the State of Arunachal Pradesh in the Honorable Supreme Court, to start. Eliza, you have the
floor. Good afternoon, panelists and attendees. I must begin by disclosing that apart from having an academic interest in the present topic, there is also a deep personal connect for me. To dissect the issue, I must first give a small introduction about myself. Born in somewhat privileged family, I was fortunate enough to have not only a good education, but also a means to start my professional life in the highest court in the land. I am currently standing counsel for the state of Arunachal Pradesh in the Honorable Supreme Court. Yet I must admit, here and today, to have been at the receiving end of a racial profiling and racial discrimination. Academically, there exists no question on the legality of racial equality. It is no longer asked whether one race amongst the many and wonderful ones that make up this country is inferior to others. Academically, at least, we all enjoy constitutional guarantees of racial equality. Speaking for individuals and people belonging to Northeast, I must admit with all the candor that racial profiling, segregation, and discrimination does exist. It existed when Niro Tanya, a young college student, was killed in the Lajpat Nagar area of Delhi for having dared to have a confrontation with the shopkeepers. The incident brings in focus the feeling of otherness that is embodied in the societal consciousness of our biggest mega city. A look at the judgment of conviction would show the horrific trial of events leading to his death. He entered the shop with the intention of making a purchase and had gotten angry when the shopkeeper inside started making fun of the small northeastern boy who had chosen a youthful red color for his hair as a means of self-expression, perhaps symbolizing the energy and joy of youth, perhaps indicative of the oceans of upcoming opportunities that lay before him. Angered at the unprovoked criticism, he banged on the glass countertop, breaking the same. He made an immediate reparation for the damage. However, by that time, he had injured the fragile ego of the shopkeeper present. What resulted was an inhuman and brutal death. What was incredibly shocking, perhaps even more so than the incident per se, was that it happened not in the dark alleyway away from the hustle and bustle of the city, but instead in the crowded market. It happened under the glare of CCTV cameras and mobile phones. It happened in front of hundreds upon hundreds of people, and not one among the many present intervened to stop it. It existed when the Goan passengers on the board an Air India flight thought it fit to harass a Northeastern air hostess, demanding that she produce the proof of her Indian citizenship. My own sister just last year suffered an unimaginable loss of miscarriage. What was made worse was the fact that when my family went to collect the remains of the child from the hospital in order to give him a traditional farewell and cremate the body, the resident and the police saw fit to detain them on suspicion of infanticide and feticide without following any rational guidelines or procedure established by law. It was only when I and my officer's senior partner reached and created a ruckus in the police station, they decided to admit their mistake and dismiss the entire issue as misunderstanding. The ordeal was, however, far from over. We came home only to face media coverage on the issue. The media had identified us as Northeastern culprits, a categorization done without any fact checking. It was only on the back of our office standing that the news aggregator challenged the headline from Northeastern culprits committing feticide to that of Northeastern discrimination. The final incident that I wish to talk about is when some individual saw fit to comment on my appearance and follow me home in a car as I walked back home at 5 p.m. in the afternoon. What I wish to discuss is not the incident itself, which is unfortunately relatively very common, but rather the conversation I had with a Northeastern police officer who came to take my statement. What caught my attention as a lawyer was a confession of facing harassment herself. I myself have been harassed many a time, madam, even as I walk back home in my police uniform, she said. The list above is merely indicative of the daily realities of one racial minorities. I'm sure that my brothers and sisters of other racial minorities have their own stories of harassment and discrimination. People from Bihar are discriminated against in Mumbai. North Indians find it hard to exist in Bangalore. People from Madras and Tamil Nadu face jeers and slurs in Punjab. The reality is that instead of the situation improving with time, the fault lines are getting deeper. The recent corona outbreak and the border skirmish with China have worsened the situation for the Northeastern individuals. So deep are the racial fault lines that many treat us Northeastern not just as a metaphorical other, but rather as an enemy with the slur chinky, epitomizing their feeling towards us. We've been reduced to a personification of a societal punching bag, with many individuals in metropolitans choosing to show their patriotism and concern by targeting Indians with Mongolite features. This resulted in Northeastern being denied entry into a grocery store and being spat upon during the COVID-19 lockdown. What has caused fear in the community, which expect retaliation on account of the border skirmish with China. It is also important to mention that discrimination does not always take the violent and shocking form that I have discussed above. On most occasions, it is as subtle as it is discreet. Discrimination takes the face of a landlord denying a room to a Northeastern student. It exists when a grocery store in Mumbai refused to service immigrants from Bihar. It exists when the employee in Kerala overlooked capable Punjabi candidates in favor of a Malayali candidate. Basically, at every time a decision is made to exclude an individual on account of his or her race from any public offering, be it rental, employment, service, or other, it is discrimination. As the Western world burns over the realization of racial discrimination of Black lives, of Black individuals towards history, it is imperative that we, as the world's biggest democracy, turn the light onto ourselves. Article 38 of the Constitution encompasses the first directive principle of state policy. It reads, state to secure a social order for the promotion of welfare of its people, it obligates the state to create conditions under which social order is maintained and inequality minimized. Article 14 encompasses the fundamental right of equality before law, and Article 21 guarantees the fundamental right of life and liberty to all persons. Yet, yet, like many of our constitutional lofty goals, the one of racial equality has remained our right solely on paper. Indian society and the Indian state has not begun to tackle the issue in all earnest. The road to racial equality will need input from both state and non-state actors. The first step, however, is to acknowledge the issue. The state and civil society must accept the existence of racial fault lines and then begin detailed dialogue on how to tackle the same. One big step in achieving the same would be the enactment of Civil Rights Act, giving statutory backing to racial desegregation. Today, our fundamental right exists primarily against the state actor. Today, if a baker in Delhi decides that he wishes not to serve a Northeastern customer, the law permits him to make the state discrimination. A restaurant can decide legally to exclude individuals of certain race from its patronage. Private companies can legally decide not to employ individuals from certain racial backgrounds. Racial segregation in the private sector is thus not prohibited. A second step would be to make our institution representative of the varied racial representation. What exists today is far more adequate. Most of the national institutions have disappropriate representation from the racial minority. Take, for instance, the Office of the Learned Additional Solicitor General of India. They are the top law officers of the apex court, and there among them not a single representative of the Northeastern community that I know of. Now, I must clarify this is by no means an attack on the individuals who occupy these high offices. The senior advocates who don the mantle of AHAs are not lacking merit. They are no doubt the top advocates of the day, and each has stellar integrity and acumen. But having said there is no doubt an identifiable absence of racial minority therein. We must also have the state undertake large scale of desensitization drives, both in professional institutes like the police as well as those of the general public. On many occasions, it has been found that the root of individual action of discrimination is societal bias rooted in an abject lack of knowledge about the culture and tradition of racial minority. These are, as I mentioned, preliminary suggestions given offhand. What is need of the day is informed debate taken up alone and done by the highest level of the government. Thank you.
Thank you, Ms. Elizabeth. I would now request Senior Advocate Ms.Meenakshi Arora to please take over. Ma'am, Meenakshi ma'am, your mic is muted.
So I hope I'm audible now.
Yes, ma'am.
Yes. So it is Ms. Barr's talk of discrimination against persons from Northeast is shocking revelation as to how discrimination works as a tool of social segregation and exclusion, where it's practiced, whether it gets practiced directly or indirectly. In fact, there is an NHRC report of December of 2014, which had also flagged the issue of large-spread racial discrimination practiced against persons from Northeast because of their Mongoloid features. This, I guess, has become much more acute in the present context and circumstances today, given our disputes which have arisen with our neighbor at this point in time. Having said that, all forms of private discriminatory activities, be it employment, housing, access to public goods, they continue to flourish. Unfortunately, I would say neither our legislators nor our courts have given it the attention that the issue really commands. We do have a protection of Civil Rights Act, but this act is very limited in its scope and it only touches on to people of untouchability. It really is not enough to cover all the other aspects that arise, more particularly the ones which is discrimination of the present form. A demand for legislation in the nature of Civil Rights Act of USA or an Anti-Discriminating and Equality Act is long pending. In fact, Dr. Shashi Tharoor had moved a private member's bill in 2016, but to no avail. Now, these are the acts which would take care of discrimination that arises and give in the private lives, that is, private individuals as to private individuals, and therefore give a remedy to address them. Unfortunately, the legislations with respect to social and other gender rights, etc., are notoriously slow in coming when we compare them with their commercial counterparts. They are very simple examples. In 1985, the Supreme Court recommended the Uniform Civil Code. We haven't seen the light of day, but that's one thing. Let us look at legislation which pertain to women's rights, which is whether it was sexual harassment, where the judgment came in 1997 and the legislation came only in 2015. Then the amendment of the sexual offences. There were law commission reports which came right from 1970s and the judgment of a Supreme Court in Sakshi in 2005, and the legislation found its way only in 2015, and which was after that horrific Nirbhaya case only that the parliament rose to the occasion to bring about amendment to the sexual offences provisions in the IPC. I can only say that our parliament, the legislators, have very little time for these mundane rights of ours, and that little people like us really need. So if that be so, and legislation is a necessity, but it's not seeing the light of day and it is slow to come by, then what would be our remedy while we wait for our legislators to arise from this slumber and to legislate on these issues? Having given it some thought on this webinar, I would say that against a state, we have a remedy by filing a writ petition. What then is our remedy when it comes to a private entity against acts of discrimination, like my colleague just mentioned? These acts of discrimination can have a criminal color or a civil nature. So far as they are of a criminal nature, which could be racial violence, physical harassment or such, they have a limited remedy which has found in the criminal procedure. But unfortunately, we find that the police normally tends to push all of these actions against Section 153B, which is namely a hate speech, which is nowhere near what it really does need. I mean, it's not necessarily always a hate speech, but that's what we have seen in many cases to be happen. But where it comes to a discrimination which has a civil color, let us take an example where a private employer or a firm refuses to consider a job application, whether on the ground of religion or any other racial reason, or like a private builder who refuses to sell his flat to a particular religious denomination. What then is the remedy there? That is where, if there was a legislation, there would have been a remedy. But today we will have to find our ways. What would we do in the meantime without in absence of that particular legislation? The problem is actually much more when we deal with these private employers in the matter of housing, access to public places, educational institutions, etc. I tried to look at what the other jurisdictions have done in this regard. Well, undoubtedly, most of the jurisdictions do have what is the Civil Rights Act or an anti-discrimination law in place. But there have been certain instances when their courts addressed these issues when these legislations were not there. For example, United States or even Canada or European courts were the very first ones to do so somewhere in the mid-20th century, where many house owners would draft their documents or make a covenant in their documents where they would say we will not lease a property or sell a property to persons of Negro or a Mongolian race or people of objectionable nationality. Now, you are entitled to have a private contract. It is open to a person to have a contract, particularly in a country like US, where it's very difficult to put in the fetters. But there was no legislation at the time. The court found innovative solutions. The United States, the American Supreme Court, refused to enforce these contracts altogether. The Canadian, because the United States Civil Rights Act came in only in 1964, and much of this was before that. The Canadians held that segregation and confinement of a particular group or a particular business or residential group was against public policy. So they took a principle of public policy from their constitution. So they said it's against the public policy of a state, and therefore that public policy will override your right of freedom to make a contract in whichever way that you so wish. South Africa had a very interesting history. The Western Cape High Court in South Africa, in a case of a Minister of Education versus Cyfred's Trust, was faced with a challenge to a charitable testamentary trust, which was executed by a will. Now, all of us have a freedom to dispose of our assets the way we choose by way of a will. There can be no fetters to that, mind you. So here a gentleman executed a will, and he said he would provide bursaries for study abroad, but restricted them to people of only European descent, and specifically excluded the Jewish descent and all females of all nationalities. Now, this trust was being administered by a public authority. So the minister went and approached the court saying that please delete this discriminatory provisions in a trust because they go against our very policy of a country. This challenge was upheld by the High Court of the Western Cape Town of South Africa. Because I'm mentioning this High Court because the Supreme Court or the Constitutional Court of the South Africa would take now a different view many years later, and how progressive it was and how retrograde we get sometimes is what was the comparison. The thing that the court held, the challenge was upheld on the basis of existing principles of common law, rather than applying the provisions of equality clause in a constitution. Because if you apply the equality clause in a constitution, then there is also a right of freedom to make your will as you so wish. So they went on the principle of common law. The question that came to be put by the court was whether the contested provisions were contrary to public policy and therefore unenforceable. The court held that the limitation of eligibility for bursaries on the basis of European descent constituted an indirect discrimination based on race or color, while the exclusion of Jews and women constituted a direct discrimination against that particular segment. The court then went on to apply the international conventions which had been ratified by the South African government, principles of public policy, and with that it sought to overcome the right of freedom to make a testamentary disposition or the constitutional values and deleted the offending clause. But this story doesn't end there so far as South Africa is concerned. In 2017, in James King versus Cornelius, the Constitutional Court of South Africa, in a challenge to a will which established what is called fideicommissum, which by a will discriminated against all female descendants and allowed inheritance only to the male descendants. Now, this came to be challenged, and the female descendants or their heirs challenged that particular clause in a will, saying that it is discriminatory. The South African court noticed this very progressive judgment of the High Court, but went on to say that discriminating provision in a will occur in a private and in a limited sphere of testator. So now it brings in the private rights to discriminate and their direct descendants, and it affects only a limited number of people in a limited duration. Therefore, the court chose not to follow the common law but upheld the freedom to make your to make your wills and overlook the private discrimination here. But there is still little bit hope on the horizon. The US Supreme Court very recently, as late as on 15th of June 2020, in Bostock versus Clayton County, held that an employer cannot fire an employee merely because of their being gay or transgender. But then the US has a Civil Rights Act, and the US Supreme Court went with the Title VII in that particular Civil Rights Act, which outlaws any kind of a discrimination at workplace on the basis of gender, religion, sex, national origin. And therefore, the need to have such a legislation is there. But then let us see, how do we benefit from it? We have just our IPC and our constitution to look at the moment. There are certain legislations such as the Scheduled Tribe Atrocities Act. There is a Protection of Civil Rights Act, which is actually really quite nothing, only deals with the untouchables. They do not provide for the wider protection against discrimination in the private setup. But having said that, we have some room here, and I'm going to link this constitutional provision with a remedy, which remedy could be a writ remedy. There is Article 15(2) in the Constitution, which is significant, and I think we need to look at it and apply it maybe a little bit more rigorously. Article 15(2) says that no citizen shall, on the ground only of religion. Now, this does not limit itself to the state. State is 15(1). 15(2) is inter se, in respect of private entities, that is, citizens inter se between themselves. So it says, no citizen shall, on the ground only of religious, race, caste, sex, place of birth, or any of them, be subject to any disability, restriction, or a condition with regard to. Then it starts to limit where it is going to apply. So it says, access to shops, public restaurants, hotels, places of public entertainment, and goes on to say wells, waters, etc. But the point is, this word shop, which is used in 15(2)(a), is this word shop that is used is merely an access to a shop, or does it have anything more that the Constitution makes us envisage? Dr. Ambedkar, on 29/11/1948, while clarifying the meaning of this word shop, which was being included in Article 15(2), this is what he had to state. Now, I am putting this because this can sometimes be used to talk about private employments, and it has already been used by Supreme Court in respect of educational institutions. Dr. Ambedkar said, to define the word shop in most generic terms, one can think of it to state that a shop is a place where an owner is prepared to offer his service to anybody who's prepared to go there seeking his service. Certainly, this will include anybody who offers a service. I am using it in the generic sense. This is what Dr. Ambedkar said on a question. I should like to point out, therefore, that the word shop used here is not used in the limited sense of permitting an entry into the shop. It is used in the larger sense of requiring services if the terms of services are agreed to. So now expand this shop to the shop of an employer, service that is offered. So intersay the private rights. But however, in the final reading of a constitution on 22nd November 1949, Ajit Prasad Jain discussed this particular provision in its content, in its context of social discrimination against women, untouchables, and other groups. Perhaps now it is the time to address this particular provision of 15(2) with respect to other groups, which Ajit Prasad Jain said in 1949. He said it deals with women, it deals with untouchables and other groups. So what are those other groups? The other groups today would be people who face private discrimination of the like my colleague mentioned just now, which discrimination is in matters of employment, housing, and whatever form that you may face otherwise. Relying upon this Article 15(2), the Supreme Court in IMA versus Union of India, that's 2011-7 SCC, applied this interpretation of shop to educational institutions, holding, and it stated that private sector which offered such a facility ought not to be conducting their affairs in a manner which promotes discrimination and disadvantages. So the Supreme Court applied this shop, used the phrase shop in 15(2), and said even a private sector cannot promote its business in a manner which will be discriminatory or disadvantageous to certain people. But we still have a setback, which was in 2005. In the Zoroastrian Cooperative Housing Society, the Parsi Housing Society prohibited selling of its property to any non-Parsi. But this came to be challenged. But the Supreme Court upheld this by saying that the Parsis have a fundamental right of a freedom of association and their right as minority to preserve their culture, and more particularly by refusing to apply constitutional principles to private contractual acts. So where we went one step further in 2011, we were in matters of housing one step back in 2005. And all this needs to be re-educated and sometimes perhaps needs to be rediscussed in very short near future. Now I come down to a remedy. If we expand our 15(2) and we use it as perhaps a tool in absence of a legislation till the legislation comes about, you perhaps have a remedy of a writ jurisdiction. BCCI clearly held that you could have a remedy of a writ jurisdiction in respect of those which carry out any kind of a public functions. The phrase exactly used in BCCI was, the question whether BCCI is a state or not under Article 12 will not make a material difference, as the same discharges public functions, which makes it amenable to jurisdiction of a High Court under Article 226. But I would today leave you with this discussion on a note of the old judgment of MC Mehta versus Sriram Foods and Fertilizers, 1987 1 SEC, where Justice Bhagwati at that time, in his minority view, sought to expand the jurisdiction, the writ jurisdiction, or the concept of a state under Article 12 to private entities. The judgment clearly said that in this particular judgment, since there had been no discussion, they did not finally lay it down. But there is a need now to address this issue. And just to end it there, I would just like to read a few lines out of Justice Bhagwati's judgment in MC Mehta versus Sriram Foods and Fertilizer. This is what Justice Bhagwati said. Mr. Diwan argued very rigorously that please do not apply the test of 32 or a writ jurisdiction, because Sriram Foods and Fertilizer is a private entity, so you cannot apply to us the writ principle. Justice Bhagwati said this. Before we part with this topic, we may point out that this court has, throughout in the last few years, expanded the horizon of Article 12, primarily to inject respect for human rights and social conscience in our corporate structure. The purpose of expansion has been not to destroy the raison d'etre of creating corporations, but to advance human rights jurisprudence. Prima facie, then he goes on. Then Justice Bhagwati says further in the same paragraph, paragraph 30, whenever a new advance is made in the field of human rights, apprehension is always expressed by the status quoist that it will create enormous difficulties in the way of smooth functioning of a system and affect its stability. Similar apprehension was voiced when this court in R.D. Shetty, that is the Airport Authority versus R.D. Shetty, brought public sector corporations within the scope of an ambit of Article 12 and subjected them to the discipline of fundamental rights. Such apprehensions expressed by those who may be affected by any new and innovative expansion of human rights need not deter the court from widening the scope of human rights and expanding their reach and ambit if otherwise it is possible to do so without doing violence to the language of the constitutional provision. It is through creative interpretation and bold innovation that human rights jurisprudence has been developed in our country to a remarkable extent, and this forward march of human rights movement cannot be allowed to be halted by unfounded apprehensions expressed by status quoists. I would leave you with that note. I would say we have lights, we have directions which the judges who were really progressive in their views have left us. We are at a stage where if the legislature is not going to do it for us, we have to go out and take this in our hand and test our waters and ask the judges and the courts to now interfere and to protect this private discriminatory practices, be that in the field of employment, be that in the field of your housing, be that in any manner that you face vis-a-vis private to private discrimination. I will now leave it for my learned colleague, and I'm sure she'll have a much more academic thoughts on this than I have said so far. Thank you.
Thank you, ma'am. I would now request Professor Dr. Shruti Bedi to take charge. And ma'am, your mic. You have to activate your mic, ma'am. Your mic is closed from the computer.
Am I audible now?
Yes, ma'am. We can hear you loud and clear.
Thank you so much, Abhimanyu, for inviting me to this platform, which I'm sharing with such eminent and illustrious speakers. Of course, Madam Eliza Barr's narration today of the incidents is extremely unfortunate, and it is heartrending, and this is what we are here to discuss, what is the solution to such things. Senior Advocate Meenakshi Arora ma'am has already, I think, comprehensively in detail dealt with so many different aspects, both internationally, US, Canadian, South African examples, along with the concept particularly available under Article 15.2 as a fundamental rights remedy. So I will try and attempt to add a little bit of the academic flavor, as you said. Well, we are struggling at one hand with the COVID-19, the coronavirus, and the racism and xenophobia continues to divide us and break our spirit of struggle, which is actually marked by a lot of solidarity during this time. And there has been a recent spike in anti-Asian and specifically anti-Chinese racism throughout the world. It's not just in India, but since we are keeping it to India, that's what we will stick to, because Trump called it a Chinese virus, which instigated a lot of hate crimes against people with the Chinese features. And although racism, particularly as a social issue, has had very limited visibility in the Indian public sphere, but it is extremely, as Ms. Barr has already narrated, that it has a widespread and deep-seated problem, especially in the Hindi heartland, where people from Northeast have been discriminated against with racial slurs and stereotypes that question the very Indianness. You often hear, things like the racial slur of chinky, which is persistently used by the mainland people in India to categorize the people from Northeast. You may be familiar with that. Now, Madam Meenakshi Arora has already spoken about a particular remedy which was sought to be introduced by Shashi Tharoor as an anti-discrimination bill in 2016, which actually would have been quite comprehensive because it would have dealt with all the issues which arise, particularly with respect to today's discussion. And it would have provided a lot of a good remedy in the sense of it could have curbed a lot of other kinds of racism which is being practiced, not only particularly this what we're talking about. So the remedy provided under the bill briefly was compensation and protective orders, which were to be enforced if and when required, and if anybody violated the protective order, they could be punished with fine and imprisonment. So that would have been a great thing to have on our books. But since we do not have that kind of a remedy available to us at the moment, we have to fall back on India's Constitution, the foundational document of all the rights available to every Indian citizen in this country. And here, Senior Advocate Meenakshi Arora has already at length discussed the applicability of Article 15(2). And my discussion today would be to sort of try and include this perspective of racism under Article 17 as another form of untouchability which we are experiencing now. Because untouchability, which is centrally based on caste under Article 19 as we understand, is not simply limited to that as per my understanding. And I'm going to give you two cases of the Supreme Court. One is a majority judgment and one is a dissent in the 1962 case. So only these two cases which I'm going to rely on to put forth my argument that we already have a fundamental right of untouchability. We have the protection of Civil Rights Act of 1955, which particularly targets this kind of untouchability. And we can sort of give it a wider meaning to include the concept of racism, which actually results in untouchability at a larger level. So, you know, even if you look at the situation of the blacks in America, the Americans from 1861 to 65 had a very long and bitter civil war, which was fought in the US. And the cause of the war dispute was, of course, slavery. Finally, of course, at the end of it, Black people were emancipated, and there were amendments brought in the American Constitution. And finally, the Civil Rights Act of 1875 was passed. Now, this was an act to protect all citizens in their civil and legal rights. And that act created what we now call horizontal rights. That is the rights enforceable against private parties. Because in our constitution, we say that the fundamental rights are only available against the state. So here is where we bring in the concept of rights being made available against private parties. And that act proceeded on an understanding that racism was, you know, more than just a function of a state, and it was also a deeply embedded. It was deeply embedded within the social fabric, and the seemingly private expressions of racism, whether they involved access to public spaces or other areas which Senior Advocate Meenakshi has already spoken about, was to be tackled through this act, which of course is also dealt with under 15 clause 2 of the Constitution as enumerated previously. Now, in India, we have a similar situation to that. And that is the concept of racism as we understand in India with respect to particularly pertaining to today's discussion, the racism of the new Chinese looking, the Northeast people. Now, here it is the Article 17 which becomes very important. And I would like to rely on, firstly, the Supreme Court under the Sabrimala question. How I want to take the perspective of how Sabrimala, the question in Sabrimala, which was whether the the interpretation of Article 17. See, Article 17, which prohibits untouchability and its practice in any form. If I may be allowed to actually read what is Article 17. Article 17 particularly says untouchability is abolished and its practice in any form is forbidden. The enforcement of disability arising out of untouchability shall be an offence punishable by in accordance with law. Now, there was a disagreement between Justice Chandrachud, who was a part of the majority decision in Sabrimala case, and Justice Indhu Malhotra, who dissented on the interpretation of Article 17. Now, the question was basically with respect to the exclusion of women between 10 to 50 from the entry into the Sabrimala temple, whether that fell within the scope of Article 17. Now, how was this relationship analyzed by the judges? The relationship between menstruation based on exclusion and Article 17. Now, Justice Indhu Malhotra was categorically of the opinion that Article 17 was intended to prohibit only caste-based untouchability, and it could not be extended to include any other form of social exclusion. Here they were talking about the women between 10 to 50. Whereas Justice Chandrachud did not, he did not disagree with what Justice Malhotra said with the centrality of the caste-based untouchability of Article 17. But what he said was that Article 17 is symbolic of the centuries-old struggle of social reformers and revolutionaries in India, where there is an attempt to make reparations to those whose identity was subjugated by society. And he particularly said that he referred to the Constituent Assembly debates where a lot of the framers believed that when they added the words, I'm quoting, in any form under Article 17, because like I said, untouchability in any form. So the interpretation, when you're giving that interpretation to these three words in any form to a present in Article 17, they were striking at the root of all social exclusion based on structures of hierarchy or subordination without taking away from the centrality of caste-based untouchability. So, besides, see, in India, besides the struggle for independence, we have alongside had a huge struggle for the replacement of the unequal social order which is present in India. And we have been fighting for the wrongs which have been committed against certain categories of people. And that is why you have the fundamental rights, which talk about a social transformation where the society is transformed and we bring about such a transformation through the rights present in the Constitution. Therefore, the transformative Constitution of India gives to these people who have been socially denied such rights for a long period of time and bring them to an equal status and an equitable social order. Now, the Constitution, therefore, it represents the aspirations of those who were denied the basic ingredients of a dignified life. I would like to really stress on this point of a dignified life here, because the Constitution provides for an equality code. Equality code comes from 14, 15, 16, 17, 18. All these include to form the basis of equality. So there is a premise of inclusion, that there must be equality with respect to access to rights, and that this is there for everyone. It is not to be only for a few. Because even if you look at the situation of Dalits, there is sort of an over and under application of the law. When the wrong is committed in their communities, they are targeted as the wrongdoers, and when they are the ones who have been the at the receiving end of the offense, they are overlooked. So this is what happens when we talk about this kind of untouchability, which is also present against the people from the Northeast. Now, the other point, the other case which I would like to talk about is Saifuddin versus State of Bombay, a Supreme Court decision of 1962, which was basically where the majority had struck down the Excommunication Act, where you excommunicate a person from the community that he is a part of. excommunication was actually an integral part of the Dawoodi Bohra community. So they had struck down, the majority had struck down the Excommunication Act. Now, here I would like to refer to the Chief Justice of India, Sinha, CJI Sinha's dissenting opinion. And he did not agree with the striking down of the Excommunication Act, because he said that the position of an excommunicated person becomes that of an untouchable in his community. You know, in his community, an excommunicated person is like an untouchable. And if you are allowing that, that is going against the fundamental rights of the Constitution. And the act which stopped something like this was actually following the direction of Article 17, which says that untouchability should not be practiced by any person against any other person. Now, so in equating this kind of social ostracism with Article 17, Chief Justice Sinha chose to adopt an interpretation of untouchability that went beyond its concrete meaning, and it embraced a wider understanding of social and community exclusions. So this is what Saifuddin's case brings to me. And the importance lies that when we treat certain people, whether it is some women, whether it is people from certain religious communities, or we exclude them. And when we apply the principle of non-discrimination present under Article 14, 15, and 17 particularly, then we come to a place where the right of equality, which should be available to every citizen of India. See, it is not a question of whether you look Indian or not. You don't have to look Indian to be an Indian. You are an Indian because you are an Indian. So the rights are equally available to everyone, and any kind of social exclusion does not, it goes against the very fundamental basis of the Indian Constitution. And this is exactly my point of view, that the Constitution of India was trying to help people transform themselves and overcome this kind of racial practices or untouchability, because now I call it the corona untouchability, which has been triggered because of this particular pandemic. Also, I would like to just at the end point out one of the Constituent Assembly debates, where a lot of people, a lot of the members of the Constituent Assembly expressly linked the provision, this untouchability, this kind of racism and untouchability, to Article 15(2), and they repeatedly argued that their understanding of Article 17 included the right of everyone to enjoy equal social conditions, equal rights, social equality, the abolition of social inequity, social stigma, and social disabilities. And so this was the remedy which was actually given to the people to overcome their, any kind of disability in the social sphere which they were facing. And we cannot therefore give a narrow interpretation to the existing fundamental rights, whether it's 15(2) or whether it's 17. And lastly, I would just like to say that even Article 21, when we talk about right to life and liberty, we also include within it the right to dignity. When you treat a person as an outcast and you think nothing of him, and you behave in a manner which strikes at the dignity of the person, what are you doing? You're violating his very right to life and liberty of this country, which is not restricted only to citizens, but is available to every person present in India. So this is my contention, that Constitution is, of course, the last resort of every man in the country. And it is here that we must find the answers, and the answers are present, but it depends on a liberal meaning that must be given to the words of the Constitution, with the original intention of the framers being behind and backing up are instances that access to rights is available to everyone. And I would just like to end with what the United Nations uh, UN chief Antonio Guterres has said, that it is during this time that we need to show more solidarity, and this kind of the tsunami of hate, of racism, of xenophobia which has descended on the world must be overcome with compassion. And it is the political leaders of all the countries which must take the step forward and make sure that these things do not happen. It is not only the state which is responsible, it is the citizens as well. And that is the question of horizontal rights that I spoke of earlier. So with this, I thank you very much. And it has been a pleasure to be a part of this discussion.
Thank you, ma'am. We have some questions which have been sent over to us. And I'll just read them out. We have the first question for Senior Advocate Meenakshi Arora ji. I'll read that out. The question is by Mrs. Tara, and the question reads, will not any act for stopping racial discrimination morph into SOPs similar to reservation? How can we ensure that merit retains priority? Also, how will we harmonize reservation with anti-discrimination law? Ma'am, your mic, ma'am, your mic.
The Anti-Discrimination Act, or even if we look at the bill which had been moved by Shashi Tharoor, or if we look at the Civil Rights Act in the USA, they will have no impact on the reservation at all. The point is that there's a private discrimination between the private individuals. For example, if a company has this silent, discreet policy that they are not going to employ people of certain religious belief, now that would be completely a discrimination on grounds of religion and would not be permissible if we had an anti-discrimination act of that nature. Where would there be a scope of any kind of a reservation out there? I don't see a conflict happening between a reservation and an anti-discrimination law, because anti-discrimination law will only allow everyone to be treated and considered depending upon their being suitable and not to be excluded. That is no direct or indirect discrimination based on their caste, race, religion, whatever other features that may be. So it's a right of, it's an inclusion and not an exclusion, but does not really fit in at all with the reservation. If Shruti has something else to say, I would.
Yes, I'd just like to add, actually, the anti-discrimination law, which was moved by Mr. Tharoor, actually sort of casts a positive duty of practicing diversity. You know, it makes it mandatory for organizations to carry out anti-discriminatory and diversification duties, because it says that you must provide scholarships, you must find out recruitment means to in terms of more inclusiveness and targeted advertising, which will help people to feel more inclusive in this whole process. And in fact, he goes a step further and he says they must prepare and submit an annual diversity index report to the state equality commissions, to ensure that this is followed.
Thank you, ma'am. The second question that we received is for Dr. Bedi. I think it's linked to the present one itself. I'll read it. It's by Mr. Hitesh. It says, during the course of the seminar, the panel has referred to the US Civil Rights Act. My question is, should we follow the US performer or should we find a solution that is uniquely ours?
Well, the answer is very simple, that we must borrow with intelligence, which means that we have examples before us and we need to look at what they have, what problems they have faced, and then modify it according to our present situation. And I think actually the anti-discrimination law of 2000 bill of 2016 is quite well, it's very comprehensive. It covers every kind of discrimination. It provides really good remedies which are practical to follow. So I think we don't even need to look at any other country or any other law. We already have such a bill. We just need to get it through.
Thank you, ma'am. We'll take one final question, which is directed to Ms. Barr. So the question is by Mr. Pull. It reads: we have an already stretched legal adjudicatory apparatus. Will not a new Anti-Discrimination Act choke the system?
Well, we cannot ignore the fundamental rights on the grounds of infrastructure deficit. What says we can do as a society needs to upgrade our legal infrastructure in order to ensure that all legal remedies retain their effectiveness. Secondly, I fully understand that the recommendation made here are only preliminary. The executive will have to take an effort forward.
Would any other panelists like to jump on this? The idea that a new act will just choke the system and render it non-efficacious?
I don't think. I think the rights have to be enforced, and there's no question of choking happening there at all. And these are very, very serious rights.
Right.
Thank you so much to the panelists. I know that these are tough times, and I'm very grateful that all three panelists were able to take some time out to discuss this issue. It is an issue that at least we at Tiwari and Associates believe to be of fundamental importance. I'll remind everyone that we will be uploading a video of the current seminar on our website. It's www.tiwariandassociates.com. It will be there on YouTube as well. You just have to work a little to find it on YouTube. Thank you again, and thank you to the panelists. And with this, we will end the website. Thank you.
Thank you.
Thank you, everyone.
Thank you, Eliza. Thank you, Shruti. Thank you.